All right, thank you for being here today, and thank you. I'm going to basically go over the basic understanding of IP and a brief overview of system intellectual property policy. So what is intellectual property? Intellectual property refers to the creation of the mind, such as inventions, which covers patents, literary and artistic works or copyrights, design patents, symbols and names and images used in commerce, which relates to trademarks and service marks, and information that may have economic value by virtue of not being generally known, which is kind of related to trade secrets. The main purpose of intellectual property law is to promote the progress of science and the useful arts, and to encourage creation of a wide variety of intellectual property and goods. To achieve this, the law gives people and businesses certain property rights to inventions and information that they create for a limited period of time, usually. This also provides economic incentives for the creation because it allows people to profit from the information and intellectual property goods they create. Intellectual property is also contains is intangible because you can't really touch a lot of the intellectual property. And it's also can't be depleted because a lot of people can use it and it won't go away. So one of the main ones we talk about is patents. Patents protect the creation of an idea or concept. A patent is a quid pro quo arrangement where the invention is disclosed to the public in exchange for a time-limited legal right granted by the government to exclude others from making, using, offering for sale, selling, importing an invention. It's also referred to as a limited monopoly. One thing it does not give you the right is the right to make. It only gives you the right to exclude others from making what you invent, because sometimes your patent invention may be a modification or improvement to another patented idea. But one of the patent creations you have, what are the criteria for patentability? It has to be new and novel. You must demonstrate that it's different from what's publicly available ideas, inventions, and products, what we also call prior art. It does not mean that the whole invention has to be novel. It can be an improvement or composition of matter, or, incremental improvements known to processes that may be patentable. So that part has to be novel. It has to be useful. Invention must have some utility or some improvement over existing products or techniques. It has to be non-obvious. What we mean by that is a person having already skilled in the field of what we call one skill in the art can't be obvious to them to come up with this invention. What you cannot patent, though, are laws of nature, physical phenomena, abstract ideas, or naturally occurring articles. One of the common pitfalls for patents is making it public. You just came up with this unique invention. Everybody wants to know about it. Everybody wants to use it. It's going to change the world. However, you got to be careful. You can't disclose it right away, because once you disclose it, you may lose rights to it. For example, overseas, they have what's called an absolute bar. What we mean by that, if you disclose before you file a patent application, you cannot obtain any rights overseas, like in Europe. In the US, you do have a 1-year grace period, but you lose the overseas rights. So once you disclose it in the US, you have 1 year to file the patent application. So the best idea is to don't disclose it right away. And if you don't need to talk to a company, it's better to get a confidentiality agreement, or also referred to as non-disclosure agreement, between you and that company before you disclose it to them. Let's go to copyrights. Copyrights are works of authorship. It gives an exclusive legal right to determine what you can and can't somebody use your invention, the conditions of it, how it's copied, how it's displayed, how it's formed, how it's distributed to others. Copyright protects the original works of authorship, but not the concept of idea. For example, how you write the idea or came up with is protected, but not the idea itself. For example, that's what patents protect, is the idea that you come up with. You can't protect titles, names, individual words, short phrases, or slogans. Those two kind of go to trademarks. The idea, procedures, methods, system, processes, and concepts are not protected. Facts are not protected. But how you write it down on the piece of paper, how you organize it on some way, can be protected. That's the works of authorship. Also, it can't contain, what's not protected is public domain information. But the nice thing about copyrights is it's cheap to get, it's easy to file for. If you're an author, sole author, you get the duration of copyright is the life of the author plus 70 years. Joint authors, which whoever the last surviving author plus 70 years. But a work for hire, which just means it's owned by a business, then that lasts for 95 years from publication or 120 years from creation. And a work for hire is basically where a person is hired to develop a certain item. For example, graphic artists who develop presentations for the university, they're a work for hire, and so on. Trademarks. It could be a word, phrase, logo that identifies a product or service with the source of the product or service. It can also be used to establish in the mind of the consumer the quality of that goods or service. For example, you see, as you well know, you see a little apple with a bite of it, you know it's Apple Computers. You see a swoosh, you know it's related to Nike and their products. Now, we also have trademarks in the system. We have it for certain products. I'm going to pick on AgriLife because Jenny's coming up next. They have certain plants that come up when they sort of trademark word. They have turf grass that has trademarks that they use with it. So we do obtain some trademarks for the system besides just the big name of the members. The other thing that you have are trade secrets. And a trade secret is information that is usually not disclosed publicly and is managed in a manner to prevent the release. And it's usually there to have a competitive edge. For example, some formulas, methods, pricing information, client information, who to contact, and sometimes more importantly, what not to do is very good to be protected as a trade secret. Sometimes, the right order to do things in, it can be a trade secret. It can be very competitive and very beneficial to a company because the other companies don't know which way to do this and it costs them a lot of time and money to do it, whereas this other company has it and they can make money off of that. So now we're just turning, like I said, this was a brief overview and backgrounds, and I'm sure people have questions, but we're going to go turn into the system intellectual property policy. And basically, A&M policy says that the A&M system owns intellectual property conceived and developed by IP creator, so applies to patents and copyrights, as a result of activities related to the individual's employment responsibilities with the system or member, with financial support from the system or its members, or financial support received from a third party then administered by the system or member. So that last part is kind of relating to sponsored research, grants, and so on. Or we own it with significant use of system or member resources. For example, if you're using a supercomputer to come up with something, that could be significant use of resources. But using your old personal computer or the computer that we give you just to type up something, like your own pedagogical works, that's not to be significant use. So like we do not own, the system does not own your pedagogical works, scholarly works, or artistic works. But there's different combinations in there, and it's kind of a little complicated, but we're just not going that detailed at this time right now. But if you have any questions, you can bring it up to myself or some of the commercialization member offices, and we could talk about it. IP policy also establishes what they call member commercialization offices to manage the IP, commercialize this on behalf. Jeannie Hurley will be talking more about that. But also what's more important for a lot of the faculty and such is that it sets out how we share revenue with the IP creators and the members. And the basic one is anything that's for patents, 37.5% goes to the IP creators of money we get in, 57.5% goes to the members, and 5% goes to this commercialization fund, which is used to help further new development. Now for copyrights, it's 40% to IP creators, 55% to the members, and 5% to the fund. Now this does not mean if we get all this money and there's patent expenses come off first, then the remaining part is shared this way. Also, the IP policy allows the system to create certain startup companies. This is not the same as a professor starting up their own startup companies. System, and we don't do this very often, but we do once in a while start up a company to commercialize system IP. Now, the professors or other companies, the members can take equity or help start up some of the, for professors, and we may own some equity rights in that, but that's different than this one, IP. So I'd like to turn it over to Jeannie Hurley. We'll talk about the member commercialization offices and other aspects.
Thank you, Mark. I'm Jeannie Hurley with the AgriLife Commercialization Office, and I'm going to here explain a little bit more about these various offices. I've been here in the system working in commercialization for a little over 20 years now. So as Mark mentioned, the system intellectual property policy sets out that there are certain offices that have a responsibility for managing the intellectual property that's owned by the system. So if you go back a long ways, the office was originally referred to as the Technology Licensing Office, and the intellectual property was all managed in a centralized office for the system historically. But over the last couple of years, we had a change in the policy, and there have been a few other offices now that have been established. I'll try to explain a little bit. There is still a central office that is known as the Texas A&M Technology Commercialization Office, or the TTC. This office now, though, is primarily serving as an accounting and support function activities for these commercialization offices. The licensing personnel that do kind of, you might refer to as your hands-on, really project management of the intellectual property for the system, have been dispersed out to 4 member commercialization offices, and we have them listed there on this slide. Each of us has maybe a slightly different name, but in policy we're referred to collectively as commercialization offices. So if you're a researcher and you previously worked with someone in the central office, if you're in the same department, then likely your licensing person that you worked with previously is now residing at one of these commercialization offices. So I'll take the engineering experiment station office, for example, and their office is primarily managing intellectual property that is resulting from faculty and staff that are residing under the College of Engineering. I am in the AgriLife office, and we're managing intellectual property that is coming out of the College of Ag and Life Sciences and the various AgriLife centers around the state. And some of the, we also work with some of the vet school faculty as well. But so does the Texas A&M University Commercialization Office, who actually is better known as TAMU Innovation Partners. You might have seen that name. And this is the University Commercialization Office, and they work with the Health Science Center and all the other departments that are under the Texas A&M University. And then we also have an office with the Transportation Institute. And so this is primarily where you're, again, as I said, licensing staff are residing in these offices, but it's not like we're operating in isolation. We have a constant communication back with the central TTC office, because disclosures are all still recorded in a central place in a database that is housed at the TTC. All the agreements that we do are recorded in the database that's held at the TTC office. And so there is frequent communication as well between our offices. And so it may sound like it's gotten a little bit divided up, but it actually, we all still work together very closely when it comes to managing the system intellectual property, because it's still, as Mark said, the intellectual property is in the name of the A&M system at the top level. So I just want to be clear, these commercialization offices are not responsible for administering sponsored research. That would be instead, you know, with your SRS, or also involving your contracts offices that reside in the particular members, perhaps. But these offices instead are managing intellectual property. And why is that a consideration when we're talking about sponsored research? And that is because obviously when we have contracts for sponsored research, there are provisions that relate to intellectual property that may result out of that research, whether it be a private sponsor or maybe it is a federal sponsor or state, you know, whatever it may be. There are typically going to be some terms in those research contracts that relate to how intellectual property is handled, who owns the intellectual property, and perhaps even talks about licensing and things like that. And so that's why at times our offices get quite involved when there are discussions at the sponsored research offices regarding getting these contracts in place. And so I'm just going to say generally about the IP provisions. Mark shared with you the provisions of our system intellectual property policy says that the Texas A&M University system owns the intellectual property that is created under these various circumstances. And so the goal is that any sponsored research contracts that are entered into would match what our policy says, and that if the intellectual property is created under a project, it doesn't really matter that the funding is coming, or a bulk of the funding perhaps is coming from another entity. We still want to establish that the intellectual property is owned by the A&M system. So there can be exceptions, but any exceptions are going to have to be approved on a case-by-case basis by administration. And so I'd say it's more rare for us to say that intellectual property is not owned by the system if it's created here in our agreements as a standard. Instead, we establish that intellectual property created by our employees is the systems. If the company that we're working with or other entity that we're working with happens to develop some intellectual property in the course of that particular project, then we would agree that that entity would own the intellectual property that their employees create. Sometimes we do have a sponsor that wants to say that because they're funding the research that they should own the intellectual property instead of the system owning the intellectual property. That's just something that we hear, and we're going to talk a little bit more about that perhaps. But again, what we want to do is stick with our position that matches our system policy. So one of the things, again, whether it be private funding or it be federal funding, the other provisions that come along under those contracts are going to be related to not only the ownership of the intellectual property, but also like reporting of that intellectual property back to the funding entity. So disclosing intellectual property. So in the course of a research project, intellectual property may be developed, or sometimes you may have existing intellectual property before going into a research project that might be used for that research project. And so in any case, there is a process for disclosures of intellectual property to be made. Actually, policy requires that our researchers, if they have a new invention, that new invention be disclosed to the system. And there are forms that we utilize to obtain that information when the disclosure is submitted to it, and it can go straight to the TTC office, or it could be sent to any of the member commercialization offices. And then what we will do is contact the TTC and make sure the form is submitted to the TTC, because again, they hold the central database. And so this form basically is just a series of questions that ask the researchers to describe their invention so that we have a good handle on what it is that they feel that they have discovered. And we ask questions about novelty, like Mark was talking about, and competing technologies and things like that, but also very importantly, background that resources and information that may have been used to generate that discovery, who the folks are involved, who was it that created the discovery, the invention, and also in particular, we need to know where did the funding come from that supported that new invention. All these are things that a licensing officer will review when they get the invention disclosure, and then usually contact the researcher for more information, because again, we're looking for two things. It is, what is the technology, so we can try to understand what it is that's novel here and what the true invention may be. And then also, we've got to know a lot about the background so that we can establish, is this actually something that would be considered system intellectual property? And I believe Mark already mentioned this, and this is included in the intellectual property policy, that this does not include pedagogical work, scholarly works, textbooks, things like that, that faculty may develop. That's explicitly excluded for being considered system intellectual property. So I mentioned, of course, that your sponsored research, it may be coming from an industry sponsor, or it may be something that's a federal award. But I'm going to focus just a little bit on the private industry sponsored research for a moment. And that is where we get probably the most back and forth negotiations and discussions about how intellectual property is going to be handled in contracts that are sponsored research agreements with companies. And so again, our standard position is that the A&M system is going to own the intellectual property that our employees create under the project, but we would provide the sponsor of the project a first opportunity to come back to us and say that they would like to have a license for commercial purposes to use that intellectual property. And again, that's our standard position. If it's a company, we understand that they are primarily going to be our ideal licensee for that technology. Probably they're going to have an interest in that technology, and so it makes sense that they would want to be the one to have a license to commercially use the technology. I did say here that what our position is that the company is paying for the particular project, the work to be done, but there's a lot more involved when intellectual property is generated, not the least of all being the expertise and the background of our researchers and the facilities that they're using here. Yes, a company is paying money for a particular project, but they're really not funding all the full background and facilities that's being used in that research project. And so, so that is part of what we try to help explain with companies that may originally think that the intellectual property instead should be owned by them. And I just mentioned here that typically when we get into a conversation with the company about our position and kind of help them understand, and then they can realize that what we would do instead is let the sponsored research agreement handle the research project. We give them a first opportunity to have a license, and then we subsequently, once something is developed, then we can begin talking about what do the proper commercial terms look like for a license for that company to be able to utilize that new invention commercially in generating a product or a service. So just a quick touch on what does a commercial license look like? And really, I mean, it's just a written agreement with a company to convey rights in intellectual property that is owned by the system. And in some cases, again, may have been generated by a research sponsor. And so there are different terms in these contracts, one of it being the scope. So we're granting this company rights, but are we only going to grant this one company rights perhaps to our intellectual property? Or are we going to grant multiple companies rights? And so that's what I mean by exclusive being one company, or it may be non-exclusive. If it's something that's like a research tool, it may make more sense for us to grant rights to multiple companies. And in that instance, it would be a non-exclusive license rather than an exclusive license to one company. As part of this license, we go into detail about what type of rights that the company would have in that intellectual property. Also, we may specify that the commercial use by the company may only be in a particular field for a particular application. For instance, if we have something that was originally developed with animal health applications, and we have a company that is in the animal health space, we do the license with them to utilize the technology in animal health because that makes sense. That is the area that they're in. But perhaps it also has applications in human medicine. And if this company doesn't work in human medicine, then it may not be reasonable for us to also grant them rights to human medicine applications as well. And so we can actually limit that in the license that we do with the company. We can also tailor the license to be for particular region. So it may be a smaller company that only has operations in the US. And so it wouldn't make sense for us to give that company worldwide rights if they only have the capability to work in the United States or to have a network of distribution inside the US. Then we may be able to license rights to the intellectual property outside the US to a different company. And then as part of that license as well, if we're conveying the right for this company to utilize our intellectual property and they commercialize a product or a service, obviously they're going to make money with that product or service. And so part of the consideration in return for us granting those rights is that they return back to us some type of financial consideration, often in the form of perhaps a license fee or an annual fee or royalties, a percentage of their sale of the relevant product. So we also include, very importantly, I mentioned diligence milestones, because it is very important that the intellectual property is system property, and we want to ensure that when we do a license with the company conveying them rights in that technology, that they're actually not going to shelve it, but they're actually going to develop a product, because ultimately our charge is to get technologies out for the public good. And so a company enables us to do that. So we want to make sure that we have some provisions in our agreement that requires that the company develop that technology and ultimately offer that product or service to the consumer. So just a couple of thoughts here. If you're a researcher and you're preparing your proposal to submit for funding, it's a good idea to think, as you're preparing that proposal, if you already have something that's potentially an existing invention that's going to be used under this project. First of all, you want to make sure that if you have an invention, that it's not something that already has some type of obligations to another party. Obviously, if it's something that's been disclosed to our office and potentially has been conveyed rights to a company outside through a license agreement, then you may have the ability to use it for research in another research project. But we have to really look at what the existing license says to see if you're able to use it in a project with another commercial party. You very well may not be able to use that in a project that benefits another commercial party. And I mentioned the disclosure before. This is also, again, a good time to think about, oh, hey, I do have this discovery, but I haven't contacted anybody about it. Before proceeding with including it in the proposal, it may be a good idea to contact your commercialization office to discuss whether perhaps it should be disclosed to our office, so that we have a clear record before the project even starts that this is an invention that was developed outside of and prior to you starting on this research project. So just some other considerations generally with a research project or at the proposal stage as well is, is the researcher going to be using resources that have been developed under another funded project, especially if that other party is another company. Again, it doesn't mean that it may not be able to be used, but you would need to share that information so that the appropriate people can take a look at what those obligations may be, so that we can ensure that particular resource can be used under a different research project. And then Mark had mentioned about confidentiality agreements, because if there's some information that may be a new concept that you have that you really haven't disclosed yet or shared externally, it may be something that's worthwhile for us to first get under a confidentiality agreement with the other party before that information is shared in the form of a research proposal. So kind of switching a little bit into touching on a few things with regards to funding from federal agencies, and Travis Young is going to go into this quite a bit more. In particular, I was just going to focus on the requirements that we have under federal funding to report inventions. The Bayh-Dole Act was passed in 1980, and it has a lot of strict obligations about how intellectual property is handled that has federal funding. So it allows universities like ours to be able to own that intellectual property, but we do have some particular obligations that we have back to the federal government in consideration for them providing that funding. And one of those things is that the federal government then has a royalty-free license to that intellectual property to be used for governmental purposes. And then the other things mostly are with regards to reporting that we have to abide by back to that federal agency pertaining to that invention. And that I mentioned, you know, the TTC central office, this is one of the things that they're responsible for handling, is some of this reporting of inventions back to the federal agency when there has been research funding by a federal agency. So here are just a little bit kind of high level, some of the obligations that we have back to a federal agency when there has been funding from one of these agencies. And some things vary depending on the agency, but one of the things that we ask in our invention disclosure form is, what funding did you use? And so we're going to ask for the particular award, so that's something that we check. We will go and obtain a copy of that award, and we'll look at what these obligations were. So so you can just see here, like the invention has to be reported to the TTC. Again, it can come through a commercialization member office, but the invention has to be reported. It has to be submitted to the federal agency. And then we have a timeline that we have to abide by for electing title. And that just simply means that we are declaring that, yes, we do want to take ownership of the invention like the Act allows us to do. Or we may say a non-election of title. We may say we're going to waive our right back to the government, and then the government can own the invention instead. But if we do elect title and say, yes, we are going to declare our ownership in this invention, then we also have to follow through with intellectual property protection on that invention, and we have to do something with that invention. And so within a year after we say, yes, we do want to declare our ownership of this invention, then we need to file for patent protection, or maybe it's, some other form of protection. And we have obligations to report our status of our patent applications and things like that back to the agency. So there's an ongoing obligation that we have with the federal agencies when there are inventions that result from federal funding. So this is just a quick screenshot of the what is called iEdison, which is this electronic mechanism that the government has for us to submit all this information related to inventions. And so again, very important for our researchers to report which awards, which contracts were the source of funding for their inventions, because that is going to trigger the TTC office then to report through this iEdison portal that invention to the government through this mechanism here. Most of the agencies, we have the ability to report through this mechanism. This is just a listing of some of the agencies. Not all of them are yet using this iEdison portal, but quite a few of them are using it. And actually right now they are doing some beta testing on an updated version of the iEdison portal. And it's going to kind of streamline some of the things, but not that this is something that our researchers really have to worry too much about, because again, the TTC office will take care of doing the reporting. But what they need from our researchers is very clear information and being available to help, answer questions, perhaps if they have questions when they're inputting this information into the system to be reported to the federal agency. So I think now I'm going to turn it over to Travis Young to talk a little bit more about terms that are in federal sponsored research.
Thank you, Janie. I thought I wanted to touch on a little bit of the typical terms that we'll see in federal grants or contracts, because basically when we get federal funding from any federal sponsor, it comes basically one of two ways, either through a grant or through a contract. So I thought I would cover contracts first and basically mention the federal acquisition regulations, which are the FAR, and to any contract negotiator, those are, we're very used to seeing FARs. And the FAR clause that actually has the most bearing in this situation is FAR clause 52-227-14. And this covers basically ownership and regulations with regard to data that's produced in the performance of the contract. And generally, under this FAR, the contractor must obtain permission from the contracting officer at the federal agency before we would assert copyrights in this data that's produced in the performance of the contract. However, contractors, which in this case would be the university or one of the member agencies, we are allowed to do this without prior approval and assert copyright on our own without getting the contracting officer's approval if we have certain alternates in place. And I have referenced here alternate 4. Under this clause, it grants us permission under 227-14 to assert the copyright without having to ask. So typically, whenever we're negotiating a contract, we want to make sure that we put this alternate in place so that we automatically can assert copyrights to data, and software and things that we do without having to ask their permission. And as Janie mentioned under by dole, as part of this clause, we grant the government an automatic paid up, non-exclusive right to basically prepare derivative works, distribute this for public display, and to use on behalf of the government. And this is part of the general rights that we grant to them. Even though we would still own the copyright, we grant the government these rights under this FAR clause. Now, for computer software, that's a little bit different than technical data. For computer software, the scope of the government's license includes all these rights, except they don't have the right to distribute to the public. So it's a little bit different for that kind of copyright. Now, another way that we can handle copyrights and stuff that we would receive with a grant is that FAR clauses don't come in grants. Grants are a little bit less stringent in that it's already automatically assumed that we can assert the copyright in anything that we create. However, the rights that the federal government still has with regard to the ability to reproduce, publish, and otherwise use it for their purposes are still there under a typical grant. And this is something that's found in the uniform guidance that basically covers all federal agencies. Now I'm going to talk a little bit about data, and this is how it's defined under the FAR. And basically under their definition, data means anything that's recorded, regardless of the form or the media on which is recorded. And typically this involves either technical data or computer software. And this covers, the examples are writings, films, sound recordings, picture reproductions, drawings, designs, graphic representations, everything. And also it can include computer programs and algorithms and things like that. So it covers quite a wide variety of items, but it does not cover things like financial, administrative, cost, pricing data, and management information. Those things are not covered under the definition of what would be considered data. In most cases, under either a contract or a grant, we grant to the government data rights that I mentioned before, that it's basically their ability to use the data. And in most cases, although we retain ownership, they have the right to use it for government purposes. However, there's different levels of rights that we can grant to the government, and I'll go into that here in just a second. As I mentioned, the federal government has the right to basically, reproduce, publish, and otherwise use for their purposes. And, they also have the right to authorize others to reproduce, publish, or otherwise use this data for federal purposes. Most of the time, this doesn't cause a problem because, they're not in direct competition if you were to license this to a commercial entity to develop it. It's just, there are instances where we would want to potentially modify what rights are granted to the government, and there are processes for doing that. Typically, there are different levels of government licenses. Typically, 99% of the time, what we give is what's called an unlimited rights license. And that means that the government can pretty much use the technical data or the software for anything they want. They can modify it, they can reproduce it, release it, and they can use it for pretty much any purpose whatsoever. Most of the time, that's what the government starts with, and that's what they want, and we're happy to give that. There are some times where we may be bringing in, for instance, some software that we've developed ahead of time, and we kind of don't want to have them be able to use it for any purpose whatsoever. So we can actually modify these rights. And one of the modifications is what's called a government purpose rights. And that's a license where we say, yes, you can use this, modify, reproduce, release, and disclose the technical data computer software just within the government without restriction, and outside the government, but just for a government purpose. That's one of the levels that we can do. And the next level down is a restricted rights, which basically says, this is, for instance, something that we would only apply to computer software. And this says that we're saying, okay, we're giving the government a right to use this, but they can only use it on one computer at a time. They can't use it government-wide, and they can't transfer it to another government agency. So it's kind of limiting, it's narrowing the scope of how they can use this. And then even further down, there's limited rights, means the right to use, modify, and reproduce, but only within the government. However, these are not typically used except in the fairly rare cases, because if we assert these limitations on the government wants to know why, and we have to provide a explanation and justification for why we are wanting to assert these rights. And there are instances where we might have something that we need to protect that we're bringing to this before it's funded, and we want to make sure that we protect it and restrict the rights that the government has in these inventions. Like I said, these are not used very often, but it does come up. And this is sometimes what, like a investigator may get a question from a negotiator about, do they want to assert restrictions of rights on these licenses that we're giving to the government under a government grant. And this is kind of what we're asking. It's like, do you have something here that we need to restrict the rights on that we're giving to the government? Otherwise, we're giving them unlimited rights, as would typically be the case. So the takeaways from what Mark and Janie and myself have been kind of saying through this presentation is, you got to protect the IP that you create. And as Mark mentioned previously, one of the first things to do is contact your contracts office and discuss it with them, especially if you're considering meeting with a company or some other entity outside of Texas A&M, and you want to discuss this. You need to get a non-disclosure agreement in place. Otherwise, your act of discussing it with them, whether they disclose it or not, has already made it public, and that can basically ruin your chances for protecting it down the road. And as Janie mentioned, submit invention disclosures to your member commercialization offices or TTC as soon as you come up with something, so they can work with you to figure out, how to, protect the invention and potentially license the invention. Another important thing is to just get to know the contacts in your member commercialization offices. As Janie mentioned, she's the contact for the AgriLife commercialization office, but we could direct you to other contacts as needed to help you commercialize something and also disclose inventions that you have. And also know the terms of your sponsored research agreement related to IP and IP reporting requirements, because these are still, when we have a sponsored agreement, it's typically reviewed by either sponsored research services or your member contract offices, and they'll work with you and kind of highlight things that could be problematic or an issue. But it's important to know what the requirements are from the sponsor, and also what IP reporting requirements are either from a federal sponsor or from an industry or non-commercial, like foundational sponsor. So with that, next slide, I guess we'll just open up to questions and see if anybody has any questions.
Right. Thank you, Travis. Yes, if you have questions, you can put them in the chat and we'll address those. Or you can unmute and ask your question that way, and let us know who you're directing it to. I've got a couple of questions here just to get us started. Got one here. If a faculty member thinks that they have something that needs to be disclosed, do you prefer that they go ahead and fill out the disclosure forms and submit? Or would it be beneficial for them to have a contact with your office first to have a discussion? So I'll direct that one to Janie there with the AgriLife.
So I would say really you can do either. So we like to tell our researchers, especially if they've never disclosed anything before, feel free to just call us up and we can have a discussion before you begin filling out any paperwork. The invention disclosure forms are on the TTC website, and then each of the commercialization offices also has links to the disclosure forms. And so, certainly you can always grab one of those disclosure forms and fill it out and submit it. But you also may have reach out to a commercialization office, talk to a licensing person before you begin filling out any paperwork, because honestly, sometimes if it's something that's just really still at an early concept stage and you haven't done any proof of concept work yet, then it may be more appropriate to wait until you do some of those proof of concept studies before filling out an invention disclosure form. But I think the bottom line is, when in doubt, just contact your member commercialization office.
We have a question that says, if a graduate student is being paid on a sponsored research project and creates IP, who owns the IP, the university or the graduate student?
Take it.
Mark?
Yeah, the university or the system will own the IP. Any IP developed on our sponsored research program is specifically going to be owned by the system. And also, as a grad student who gets paid, to be considered an employee, and that's going to be owned by the system as well.
I've got another one here. While understanding that the process for each invention may be somewhat different, describe the typical process when a faculty member reaches out to your office with something that may be patentable.
So, as you said, it may vary depending on the subject matter, of course, but generally what happens is we're looking at the description of the technology to try to, understand again, what is the technology? And then we start thinking about what types of intellectual property that we could use to kind of grab that technology. Can we put property rights around that technology? And it really depends on what the subject matter is. But at the same time, we also have to look at the commercial utility. Does it have commercial applications? It's really a two-pronged approach, because we don't have the luxury, being a university system, and being able to just patent anything and everything that comes in the door just so we can say that we have a patent. We really are going to pursue patent protection or other intellectual property protection only when it makes sense for us to do so. And by that, I mean, because we believe it will enable us to have an opportunity with the company to actually further develop a product or a service using that intellectual property. So we take it through a host of questions that we ask about it to determine, again, is this something that we think that we can protect? And then also at the same time, do we think this has a market somewhere? Meaning, do we think there are companies out there that would have an interest in perhaps obtaining a license to use that intellectual property?
It says, how is the situation of IP for service project if something new shows?
Well, I mean, I can kind of address that a little bit. I mean, typically with a service project, the way we look at service projects is, if you're really doing a service project, you shouldn't be really developing anything you're just testing,
Right.
So I guess the question saying, how would you handle IP developed on a service project?
Yeah, I think the first thing is Travis is kind of saying is that is to really determine whether this is true just service, or really does it involve research, because then you're able to better determine whether a service agreement is appropriate, or maybe it should be, a research agreement, because if it's leaning itself more toward discovery that and really intellectual contribution by a researcher to carry out the project, rather than just, as Travis said, testing, really taking a protocol that the company has provided and just carrying it out, that could have been done perhaps with a contract research organization, then, that is more testing. But if our researcher is really having to use their intellectual contribution to determine what studies to be done and details of the project, then it might actually be more research, and your intellectual property terms are going to typically look different in a research contract versus a services contract.
Got another question that has come in. This is a good one. What is the best way to decide the percentage of an IP? What percentage of IP was invented by multiple researchers when they are all involved in developing the IP?
I'll just mention, basically, we leave it up to the inventors to come to an agreement. Under policy, after the invention disclosures developed, you guys have 90 days, guys and girls, have 90 days to decide how to divvy up the percentage of sharing of the invention. If you don't, then the member CEO for whoever you're with decides for you. So if you can't agree on how you're going to share it, it could easily be decided by the member CEO that everybody gets 50%, everybody's split evenly. Or it could even be doing differently other than that you want. So under policy, we're assuming that our professors and researchers all work together and cooperate with each other to come up with a solution for this.
Mm-hmm. I guess I would just add to that we see it in all different types. Some disclosures have all the contributors weighted equally. I mean, others may say 95%, 5%. It's really all across the board. Generally, there's usually a primary person that had the original concept. And so oftentimes that kind of leans itself a little bit more to a greater contribution. But ultimately, as Mark said, I mean, we leave it up to the pool of inventors or contributors to decide amongst themselves what is appropriate. We do not dictate that.
Here's another one. Does the submission of a proposal to a federal funding agency constitute a public disclosure, assuming the proposal has potential IP in there?
I can comment on that a little bit. Honestly, typically proposals that are not funded don't get published, but ones that are funded do. So, and Mark can talk to that as well. So to me, that would definitely be a public disclosure of potential IP.
Let me add to that is on all of the funding proposals, each agency has a unique way to protect confidential information. You just don't put confidential on the outside. They have specific requirements. Some require you have to mark every page. Some require you have to mark every page and every item that's. Some require a different one. You have to follow what that funding agency requires to protect things as confidential. If you have a big concern about that, the best thing to do is contact one of the commercialization offices, and maybe we'll quickly file what's called a provisional patent application to help protect it as well. We don't know. I mean, it depends on the situation. I hate to say that, but the common thing for the lawyers, it always depends. But we have to look at what's going on to figure the best way to go forward. But always read the instructions. As we tell our students, read the instructions for answering a quiz. We need to tell the professors, read the instructions when you're submitting a proposal, because we have had one who didn't follow the requirements and it was considered a public disclosure and they lost foreign rights.
Another question. If a researcher makes an invention while not working on a specific project, what are the steps for commercialization of that IP? Does the researcher typically find a commercial partner, or does TTC help with that?
Yeah, so I'll take that one. It's part of the process that I was describing a little bit earlier still takes place, and that is that we're reviewing the information provided in the invention disclosure to determine if we think we can get intellectual property protection around the invention, but then also we're trying to determine if it appears that it's something that has commercial utility. And part of the way that we determine if it has commercial utility is looking for companies that may fit in the areas for that technology, and making some contacts with those companies to begin kind of, I guess, kind of testing the waters a little bit to see if it is something that may have industry interest. And so it's your commercialization offices that are the ones that are looking for, companies to be able to engage with, again, to kind of like gauge initially, is this even of interest? And then, perhaps even to identify some companies that may potentially be licensees. And so even though your commercialization offices are going to be looking for companies and reaching out to companies, we also are very grateful if you happen to already have some particular companies in mind or contacts at companies, because we would appreciate, if you would share that with us as well, and we'll be glad to do the reaching out to those companies. But if you have, some in mind, it certainly helps us.
Mark, we got a question here. How do we start the protection process for IP? And I guess we've been talking about patents, but in your presentation, you talked about copyrights and trademarks. So you might just touch briefly on those.
Well, first off, we need a disclosure, whether it's, for software, copyrights, or patents, invention disclosure. And from after that, we decide what to do. But one thing we tend to do at the system is to file a provisional patent application. And that protects our rights for 1 year and to help find a licensee that may pay for the patent application, all the patent expenses, because it does get very expensive. One patent, and if it's very useful and very popular, it can cost you hundreds of thousands of dollars worldwide in patent expenses to cover the world. So you have to be kind of careful. So, system doesn't have all that type of money to spend out. So we tend to file a provisional that way. But for copyrights, it's not as hard because it's very cheap. I think it's $35, $50. I can't remember the exact price to file a copyright registration. And it's kind of easy to do. We don't have to go to outside counsel to do that. Trademarks, it depends on what you want to do. If you have to come up with a unique thing, it has to be, to get protection, it has to be used in commerce, interstate commerce, not just inside Texas, but it has to be used outside of Texas. And we can file an intent to use that would do this, but we have to know what it's going to be used for, how on. It's a little bit more complicated to do. We have to get a lot more information. What are you going to use it on? How it's going to look? And we tend to go file. We use outside counsel to do that, but we tend to have to get information and get a proposal and bid, and the member has to approve that to pay for that trademark application. And that'll take a couple of years a year or a couple of years to get a trademark. It's dependent upon use. Excuse me.
Thank you, Mark. Travis, probably maybe our last question here about negotiations. With industry projects, what are the negotiation sticking points related to IP, and how do you overcome the industry objections?
Mark touched on this a little bit, and so did Janie. And basically, one of the biggest issues is sort of a mindset that the industry comes in with, we're paying for this, we should own it. And that's, we touched on how you kind of have to explain to them, it's like, you're paying for this very specific project, but you're not paying for the 20, 30 years of expertise that this faculty has built over their time at A&M and other universities, the facilities that we have available, all of the stuff that's coming into this equation that you're not paying for. And that's one of the ways to explain it to them. And also, I think there's sometimes a fear on the part of the company that if they don't own it, then they won't be able to utilize it. And that's where I think it takes the negotiator to explain to them that our mission and our goal, like Janie said, is to get IP out there and get it useful. And of course, the first person we want to license this to is the company that paid to help develop it. And, we have no desire to take this from them and go give it to someone else. That doesn't make any sense at all. We want it to be out there. We want you to develop it. And, and sometimes they'll come back, well, then you're going to charge us an outrageous royalty. That's not our goal either. If we charge you something outrageous, you can't develop it. We would charge something very, very, very small, but still something that will recoup to both our inventors at the university and the university itself to help fund further stuff, but not something exorbitant that would cause you to be unable to market the invention, because in that case, we all lose. So, a lot of times when you explain it to them and actually talk to them, you can get them to a position that, okay, yeah, we're good with this. Let's develop it. If and when the IP comes, then we'll develop a license, and that would be handled through Janie's office or the other member offices. And most of the time, you can get the company to come around to that side, and sometimes it's difficult. But can you add anything to that, Janie? That's how I would kind of approach it.
Yeah, I know. Absolutely. That's exactly right. And in those discussions is sometimes where the licensing folks, in those commercialization offices may be brought a little bit more into the discussions just to kind of help. It may not be that we relay anything different to the company than what, Travis or the, contract negotiator relayed, but it's just kind of peace of mind, I think, perhaps, and just having a little bit more comfort. Okay, they may be meeting for the first time somebody that they're going to be dealing with for the commercial license, and maybe that just helps them to feel a little bit more at ease. Sometimes we even may get to a point where we share kind of our standard, like a template license with them or something like that. Just anything we can do to help them relieve that uncertainty on whether or not we're going to be reasonable. And as Travis said, thankfully, we're usually able to convince them that, we're not going to charge exorbitant, royalty rates or something like that, because, it just doesn't benefit anyone for us to take those kind of positions.
Great. Thank you, Travis and Janie, for answering that. Just want to thank Mark and Janie and Travis for excellent presentation today. Very informative.